It's not over just yet for former President Jacob Zuma. The Constitutional Court has agreed to hear his application to have its ruling against him rescinded. Zuma had until tomorrow to hand himself over to begin his prison term, but that's changing now. Let's unpack why that is, what's going on, what's changed. eNCA's Barry Bateman is here for us. Barry, dramatic turn of events this afternoon. The Constitutional Court agrees to hear Zuma's application. That's strange. Some legal people are saying it's unprecedented. What exactly influenced that?
Yeah, things happening very quickly, Omar, on this particular matter. It was in the last hour that the Constitutional Court has issued directions in relation to former President Jacob Zuma's application, rescission application, saying that they will hear the application on the 12th of July. That's not this Monday, that's the following Monday. They've set very strict timelines. On Tuesday, they want to have any opposing affidavits by any particular party that would oppose the application filed. They want replying affidavits in by Wednesday, and all other formalities related to the back and the to and froing of the paperwork related to this matter sorted out by Friday. The application will be heard virtually on the Monday. The net effect of this, as we understand it, I've spoken a short while ago to Attorney Ulrich Ruhn. He explained to me, you just touched on it, that there was this requirement in terms of the Constitutional Court order handed down on Tuesday that Zuma present himself to the police by tomorrow, failing which the police would have 3 days to secure his arrest. Now that is essentially stayed until this application is heard. And the way it would be best explained is, if you think of in a high court, for example, where you would apply for application for leave to appeal and you are granted it, the net effect of that is that the order that is being appealed is put on suspension. Although this is not an appeal, it's a rescission application, it has that effect as we understand it. So the requirement that he present himself to the police tomorrow, and the order that the police act if he fails to present himself, that is put on the back burner until this matter is dispensed with that hearing taking place in a week from Monday.
So, Barry, usually when there is any appeal, it's to a different court. And I know this is not a criminal case, but usually it's to a different court. That isn't the case here. There's only the apex court. You can't go anywhere else. You can't go any higher.
Well, exactly, and that's exactly why the President is relying on those Constitutional Court rules, which is read together with Rule 42 of the Uniform Rules of Court, where he's going back to essentially rescind or amend the order that was handed down. That is the end of the road. That is the only legal option he has at this stage. I mean, part of the application, we spoke about this earlier, that he was going to approach the High Court for a stay on the Constitutional Court order. Well, the legal experts saying that was never going to fly. It was never going to happen. Being the apex court, you can't have a lower court, or even if it was, for example, the Supreme Court of Appeal, you couldn't go to the High Court to ask the High Court to suspend the execution of a Supreme Court of Appeal a judgment. So the only application, or the only avenue that he had available, was to use this particular rule and to apply for the matter to be rescinded. You know, some people might ask, well, why is the Constitutional Court even entertaining this application for rescission? He would have to show that he was not afforded a proper opportunity to present his case to the court. That would be the grounds. And essentially, this is what he's saying. If you look at the papers filed to the Constitutional Court, he said that he was not given an opportunity to present his case to the court. He said that he was picking his legal battles very carefully because of financial implications. But that wasn't the case. He had been given an opportunity, particularly on this question of mitigation of sentence. But instead of filing an affidavit to the court, he wrote a letter to Chief Justice Mogoeng, where he was very critical of the bench, accusing it of engaging in political gimmicks. So I think he's certainly going to have a tough time explaining or trying to successfully have this order rescinded. But the question might be asked by the legal experts, and I'll certainly leave it to them, as to why the court would even entertain them in the first place.
Thank you very much for your reporting, Barry Bateman. And we'll be back with you, I'm sure, through to today, this evening, and definitely tomorrow as this story continues to develop.